The Supreme Court is now in session. The Honorable F. Philip Carbolito, Chief Justice, presiding.
Good morning, councils. Will the clerk please call the case?
This is Supreme Court case number CVA20-014. Police Officer 2 Steve Topasna, Guam Police Department, and Does 1 to 100 petitioners appellants versus Government of Guam, Lourdes Leon Guerrero in her capacity as Governor of Guam, Captain Steve Ignacio in his capacity as the Chief of Police, Guam Police Department, Mr. Edward Byrne in his capacity as Director, Guam Department of Administration, respondents, appellees. Appearing for the petitioners' appellants is Attorney Thomas J. Fisher. Appearing for the respondents' appellees is Attorney Jordan Lawrence Paloon. The panel consists of Chief Justice F. Philip Carbolito, Associate Justice Robert J. Torres, and Associate Justice Catherine A. Merriman. Attorney Fisher reserves 10 minutes.
Thank you, Madam Clerk. Mr. Fisher, you are recognized. Please proceed.
Thank you. Good morning, Mr. Chief Justice, Justices of the Supreme Court of Guam. May it please the court. As the court knows, we are here and have appealed a very discrete issue, and that is the abuse of discretion committed by the Superior Court in not addressing a specific regulation, personnel rule and regulation that we had relied on heavily in the hearing on the writ petition. What happened, I'm sure the court is familiar with it, we were looking at 8.406 of the personnel rules and regulations, which is a rule that is broken into three pieces, A, B, and C. And we believed that the court was required to look at the entire statute because we believe that that is, it provides a decisional, that particular rule and regulation provides a decisional framework for figuring out if you're going to give comp time without charge to leave, or you're going to pay double time in the event of a public health emergency. We think that that issue needs to be addressed by the Supreme Court, excuse me, by the Superior Court, and flesh out the facts to see if A is met, and whatever the decision is, we might very well be back here in front of you folks again. But
Mr. Fisher, Mr. Fisher, let me ask you. You're asking us to. I'm a little confused about what it is that your argument, because I thought your argument was looking at least this is how I interpreted in your reply brief, that you were entitled, your client was entitled to paid leave at the moment the state of the emergency was declared, whether GPD facilities were closed or whether GPD employees had been placed on leave, had no bearing on this entitlement. So you were looking at 8406A as standing alone, making that determination. But then now you seem to want us to look at the entire statute or the entire regulation. You're saying we have to look at the regulation as a whole. So do we look at it? Is it the subsection C related to A, or are they totally independent of each other?
Well, the way we see it, sir, is under A, if in the event of a public health emergency, all of Gov't Guam is sent home. That I guess is the foundational fact for this. However, that is not practical. The police need to continue to police our streets. Public health still needs to operate, et cetera, and so forth. So the legislature, the rules and regulations for personnel rules and regulations have established a situation. What do you do when Gov't Guam is sent home because of the emergency, but we still have to call people back because we have essential services that must be met? If in that case, certain folks are sent home and others are not, those who are not sent home and must continue to work are entitled to double pay. So in that sense, because we look at it as a kind of a decisional tree here, they are interrelated, but A, the very first section of it specifically states that folks get sent home without charge to leave. And that didn't happen in this case. But I appreciate the court's question, of course, but we want those issues to be addressed in the superior court, and we feel like we were deprived of the ability, or, well, the court just didn't speak as to our main argument, which was what is the applicability of 406A. And throughout the decision and order, they just simply didn't address it. And we
Was your
feel,
client charged leave?
I'm sorry?
Was your client charged leave for the
No,
time?
No, sir. He was required to continue working. And although the health emergency, I think, continues even to today, is still working. So there was no double pay, of course, and there was no leave with compensation as the statute requires. But again, I think that we're kind of getting into the nuts and bolts of this thing. But our main argument is we feel we are entitled to hear from the court on our theory as opposed to just, moving past it without looking at it. And we feel that it's an abuse of discretion for the court to ignore that. This morning, I was looking at a case out of the Supreme Court of Guam. I think it's 2016, that Koji versus Neves. And that was a situation in which an individual asked for a forum nonconvenience analysis in a child custody dispute. And the court didn't do the analysis, even though it had been requested. And the Supreme Court there said the trial court's failure to address the inconvenient forum issue, its failure to perform the analysis provided by statute, was an abuse of discretion. And we think the same thing has gone on here. We're not here in front of the Supreme Court to advocate a particular outcome, at least not yet. And that day may come in the future. But what we are here is to ask the Supreme Court to tell the Superior Court that a party has asked for a particular analysis or has brought a point of law to their attention.
But
And
sure, that's the way I see this is that the Superior Court denied your petition for a writ of mandate, issued a judgment, and engaged in before arriving at that decision, engaged in a statutory analysis of 8.406. And based on the declaration that was advanced by your client, applied 8.406. And in its analysis, based on the facts that you presented on the declaration, determined that there were certain sections that were triggered. And in this particular case, 8.406C. And you're saying, at least that's what Justice Torres pointed out, that in your brief you said, well, we are not advancing the argument. The argument we advanced at the lower court was we were governed by subsection A, and that in and of itself triggered all the events that were necessary to be entitled to this paid leave that you are claiming Officer Topasna was entitled to. And so what we have before us is a issue of not statutory, but regulatory analysis. What does the regulation 8.406 has applied to the facts that was advanced by the declaration as how that is to be applied. So I'm not understanding why we couldn't engage in that analysis and determine if your argument is, if the trial court is correct or incorrect in ruling on your arguments. And your argument was 8.406A stands on its own, and without more, your client is entitled to paid leave, and And if not, then is entitled to double time or compensatory time leave credit under C2. And so why couldn't we engage in a review of those issues?
If you were to engage in a review of those issues, I think, I assume that would be a substantive analysis. We think that, again, that statute, that rule, has 3 sections, and they're not either connected disjunctively or conjunctively. The way we read the statute is that the rule, a certain thing happens when an emergency is declared. That's well, not quite yet, but certain thing happens when an emergency occurs, and that is basically Gov Guam employees go home. And subsection B says, well, you've got to have, a bona fide emergency declared by the governor, I suppose.
So in your case, where if we were only to look at A as what you advance in your briefs, what triggers whether or not Officer Topasna was entitled to excuse absence with pay without charge to leave? What triggers it? There's nothing in A that triggers the entitlement to paid leave.
Well, I think, I'm sorry, sir, I didn't mean to interrupt.
No, because as I understand, you're relying on the executive order that declared the emergency, and isn't that contained in subsection B?
Well, subsection B, well, I'm gonna pull the rule and reg up, but subsection B, I don't think any of it comes into play if there's not an emergency. So B is explicitly says that the emergency must, I'm looking at it right now, there must have been an official proclamation of the hazardous condition by the executive order. So I mean, that's clearly a predicate. If there's no emergency, none of this is going to happen. But we're left with A and C, and I think your question is, well, A alone.
So if you don't have the executive order and you can't point to B, so what do you have to point to that A is triggered?
Well, sir, the plain language of the rule and regulation, it says excused absence with pay and without charge to leave, etc. When natural disasters or other emergency conditions create unsafe working conditions.
But
So
how is that determined?
Well, the governor, I think it's beyond dispute that the governor declared a public health emergency. I think we included that. I believe it was
isn't that covered by B, that you would say that because the governor declared by executive order an emergency, which is recognized under subsection B, then A applies?
Well, yeah, A applies and C can apply. I'm not saying that C it.
Exactly. And so that's my very point, that these statutory provisions have to be read in relation to each other, depending on the facts advanced that triggers sections of the regulation.
Yeah, and I don't know that I've ever disagreed with that, but I do know that, A cannot be read out of the rules and regulations. And so under A, if there is the emergency, well, the emergency is declared. Under A, everybody goes home and you get pay without charge to leave. Well, there's an inherent problem in sending all of Gov Guam home. And I think
there is a step that you're missing when you said when there is a declaration A is triggered. A and B are triggered. B establishes that it's necessary for this executive order to issue, and then A would come into play if there is an emergency condition which creates an unsafe working condition. I'm hearing that you don't disagree with that.
I do not disagree with that, sir. But again, there's an inherent problem with shutting down all all the government of Guam, it's simply, it'd be catastrophic, and nobody would expect that to happen. So because
Mr. Fisher, didn't the court in its analysis say that you had to establish the government was closed? It wasn't just declaring an emergency, but closure of the government, and that part of the issue with your case was there was no evidence that the government shut down, or even that Guam police shut down.
I think in the declaration we said that at least parts of Guam or parts of GPD were shut down. I'd have to go look at it again, but maybe not. But yes, the court, you're right, ma'am. The court did do an analysis of C, subsection C, but we did not receive an analysis or any consideration of the meaning of A. You know, I don't think that A is some sort of a, I don't know, precatory or hypothetical language or whatever. It has a specific requirement that when it's triggered, some things happen under A, and some things happen which need to be ameliorated. We have to call people back into work, police, etc. Now that brings into C. So if you need to go into C, then sub 1 and sub 2 says what the remedy is for the employees. But that doesn't mean that subsection A doesn't apply. So if subsection A requires excused absence with pay and without charge to leave in the course of an emergency, it seems to me that that's, you know, under subsection A, that's kind of the end of it. It's very clear. There doesn't seem to be any ambiguity, at least in this section A.
But you don't contest that these regulation subsections need to be read together. And you can't say that under B that is triggered, and therefore we only look to A. I just think that you need to apply what facts exist that triggers the provisions of a statute that you yourself concede are interrelated and need to be read together.
Well, yes, sir, and I cannot say I dispute that, but under C, where the Superior Court was, C says that when the government of Guam is shut down, some people have to come back to work. And number one, C1 has particular meaning to it, and C2 has a particular meaning to it. And under circumstances, those can apply. But what are we to do with paragraph A? Are we just going to read it out? I don't think that that's possible. Perhaps it is. But that was the argument we brought to the Superior Court, and the Superior Court simply didn't address it. And we think under Koji versus Nevis and various state court and federal court decisions that we are entitled to have our day in court as to that particular issue. That's why we're here on the abuse of discretion standard. We're saying that the court should have.
Let me just ask, because you say that when does A apply? I mean, if you look at C1, if GPD's offices are closed, and then C1 would apply. However, if GPD continues to remain open, which is not the case, because that's not what you said, your officer Topasna said in his declaration.
Well, I don't want to overstate that, sir. I think that we did mention that at least parts of GPD were closed. I don't think we ever alleged that all of Gov't was closed.
Correct. And so and that specifically has to do with the agency, not the entire government, that yes. GPD was closed, then C1 applies. But if it wasn't closed and it was completely open, then maybe the argument can be advanced that A applies. But the facts of the case that you allege is that part of GPD was closed. And so why wouldn't C1 apply?
Well, again, C1 could apply, but also A applies. If, you know, these are not conjunctive, could be one, could be the other. But under C, C provides the remedy for when all of Gov't Guam is closed. What do? Under C1, the authority can make a determination that certain people are necessary to carry out the work. And I'm under C1 here exclusively.
Right.
If certain people are necessary to perform the work, then they're providing essential services and they must come in. Employees shall be released from duty, though, without charge to leave for the period the facility is closed. But those employees, C2, those employees required to remain there get a certain benefit, and that is double pay or compensatory leave credits for the hours worked. So we see this, as a whole. We're not trying to cherry pick within the regulation just to get the part we like and ignore the rest of it. B.
So let me ask you a
declares-
question. Does your client what does your client deem himself to be an essential worker or a non-essential worker?
My client, I believe, considers himself an essential worker because his management considers him an essential worker.
So
and as a result,
if Officer Topasna considers himself an essential worker, then wouldn't C2 apply?
well, I think that I don't think that I kind of get what you're saying, but I don't think an individual employee, I don't think has the ability to, skip among the statutes to determine which one he likes. But under C2, what happened? Those employees were required to remain on duty, which he was, and we're only in C2 here. Granted compensatory leave or double pay or whatever. But in our prayer to the Superior Court, we mentioned both universes of remedy, I suppose, which is A and C1 or 2. Court focused on C1 or 2 and said that we hadn't met the requirements of it, which is we got to show that the agency is closed and certain essential workers were called in or weren't called in. But that doesn't excuse the fact that we also raised 8.406A, and the court simply didn't address that. And we felt and feel that that is an abuse of discretion. Win, lose, or draw in the Superior Court, we were entitled to have our day in court on this issue and didn't get it. I think that, and that's why we cited, Nevis or Koji v. Nevis and all the other cases. We were entitled to be heard on that issue and weren't. Having said that, and then I'm just going to kind of jump in here a little bit because I think the AGs are going to be speaking here in a moment. They didn't appeal this decision, and they raised in their opposition. All these particular issues that they simply didn't appeal and were not the subject of the appeal. So, we think that we did not meet on the road here. We just passed each other in the dark, I guess. But that's why I said that we're here on a very discrete issue. We're not asking the Supreme Court to decide 8.406 does it apply, doesn't it apply. We're asking the Supreme Court to tell the Superior Court, look at that argument and tell us what you think. If I agree with it, great. If I don't, and Jordan agrees with it, great. But if we're arguing with each other over it, then we might be back in front of you folks again. I won't belabor that point. I think I've kind of hit that horse a number of times. If the court doesn't have any further questions, I'll sit back and listen to the AG.
Well, your time is up in reference to what you've allotted, and we'll allow you your reserved time on rebuttal. And at this time, I'll recognize Assistant Attorney General Pauloon. Please proceed.
May it please the court. My name is Jordan Pauloon, and I represent the Office of the Attorney General in this case. Just as a general matter related to the briefing first, the Office of the Attorney General does recognize all of the economic hardships that have occurred due to the pandemic and the public health emergency that's resulted from it. However, this case is not about those economic hardships. This is about a very specific rule that is being relied on by Topasna to seek double compensation for what is now over a year into this pandemic. The Superior Court correctly concluded that he's not entitled to relief under this, and we ask this court to affirm the judgment of the court below. We ask that you affirm for two separate reasons. One, that mandamus is the inappropriate vehicle to pursue this claim for relief. And second, DOA Personnel Rule 8.406 is inapplicable to the facts alleged here. The Superior Court found that mandamus was the appropriate vehicle for a compensation claim under 8.406, but then proceeded to analyze the text of 8.406 to find that Topasna was not entitled to the relief he seeks. This court can decide either basis, and either basis is adequate for affirming the judgment of the court below. They can either disagree with the Superior Court on mandamus and find that it is an inappropriate vehicle, which would provide a alternative basis supported by the record for affirming the judgment. And then second, they could also affirm on the interpretation of Rule 8.406. As a preliminary matter related to something Attorney Fisher raised at the end of his oral arguments, I think that just comes to a fundamental appellate practice point where he's alleging that we waived all of these arguments, and he stated this in the reply brief, due to our failure to appeal. The government cannot appeal a judgment that was entered in its favor. And so all we are doing is asking this court to look at the entire record and the issues that were addressed by the Superior Court or presented to the Superior Court, and rule on the questions of law that they can, as they can in the first instance. So there is no issue of waiver on behalf of the government in this case, because the issues presented here are legal issues and they were presented to the Superior Court in the first instance. As to mandamus, mandamus is an inappropriate vehicle to compel a government agency to make an award of damage, or a monetary award. Monetary relief needs to be pursued, especially in employment claims, through the administrative proceedings. And Guam has a comprehensive scheme under the Civil Service Commission and personnel statutes. There's also the personnel rules, which is what 8.406 is here, that they are relying on for this claim, and they're going straight to court to seek mandamus compelling an award in the first instance. Unlike prior cases where mandamus has been found to be appropriate for to order monetary relief, in those cases, such as Lim Tiaco, the award had already been made by the agency involved. In Lim Tiaco, he had a settlement and judgment in his favor, and all he was seeking was a ministerial act of actually signing a check and turning it over to him to satisfy that award. Here, this is not a case about a satisfaction of a judgment or the mere payment of an already made award. It is Topasna seeking an award of or a monetary claim in the first instance through mandamus. This is not the type of ministerial act that is contemplated by mandamus or is appropriate for this type of vehicle. This needs to go through, these are the types of things that
Mr. Pauloon, assuming if the facts were that that GPD, state of emergency, was declared, Chief Ignacio issued a memorandum that the offices would close and release the employees where Officer Topasna was assigned, and put them on leave, paid leave, without charging their leave bank, but required Officer Topasna to come in and other officers to be on duty and considered an essential worker, and made assignments in reference to the declaration of emergency, the enforcement of that declaration. So in other words, 8.406 C2 was satisfied that there was evidence of closure of the office, and certain employees were released, and Officer Topasna was then directed to report to work and continue to perform services. So you're saying under that case, mandamus would be unavailable to direct the Chief Ignacio to either compensate Officer Topasna double pay or issue him a compensatory time off, that Officer Topasna under those facts could not request a petition for a writ of mandate?
No, even if we, that is correct. Even if we assume that that all of the requirements of 8.406 are met, which they're not in this case, but assuming that for the sake of this argument, even if you make those, you still have to proceed through the administrative processes, which culminates at the Civil Service Commission first, because this is an employment-related matter for classified employees. Guam has waived its sovereign immunity only for merit, only when classified employees proceed through the merit system. And that is outlined in Chapter 4 or Title 4 of Guam statutes, and the personnel law and the Civil Service Commission. And so you have to go through.
What about the argument that there is what is being requested here is simply for Chief Ignacio to administer his ministerial duty to either compensate, double pay his essential workers, police officers, or put this on comp time. And that was strictly what the petition was seeking. And in terms of their dispute as to the amount of money that may be owed, or how much leave time, that's for another day. But the simple ministerial duty to decide whether it's either double pay or comp time, that he is to be directed to follow the regulation.
By even merely having a choice between options here and the discretion of which one to apply, either double pay or compensatory time off, even if we're going under petitioner's theory here, that involves an exercise of discretion as to which one you're going.
The petition is not asking one or the other. Yes, the petition is just follow the regulation and decide. You decide. I'm not telling you how to decide, but just follow the statute and you decide whether it's double pay or compensatory time off.
And yes, I understand that. But if there is any question as to the how that remains open for the agency, then it involves a matter of discretion that mandamus cannot compel. What we have in this particular instance, even under their allegations, is that choice between two things. So mandamus cannot compel discretion and cannot force them into making these choices.
I don't think anyone disagrees with you, but what is being sought here is not how to exercise your discretion, but to make a decision.
And the decision that was made here is that 8.406 does not apply, which goes into the second argument, that they haven't satisfied the conditions of 8.406.
But my hypothetical is that they did. And you're saying, even in that case, mandamus is not available because there's no ministerial duty. And I'm trying to lay out the facts such that there is a ministerial duty, but you're saying mandamus is not available because there needs to be a claim going through the Government Claims Act. And we're not talking about a dispute in terms of compensation at this time and how much back pay is due and owing. I don't think Mr. Fisher is at all making any of those assertions.
But I think this comes back to the fundamental problem with this is they've exercised their discretion the administration has in finding that 8.406 does not apply. By inserting mandamus at this point, you are telling them that we are going to substitute the judgment of that applicability and then force you to make a subsequent decision underneath that. If we're going to get into review of those decisions, it needs to proceed through the administrative processes first. If we're going to, no one's conceded that all of the prerequisite conditions of 8.406 are met. The decision between saying that it's met and not is a discretionary thing when it comes to even finding the requisite facts related to the emergency itself. And those are even under the administrative rule committed to the governor in making an executive order. We do have an executive order here, but rather that particular executive order implicates 8.406 and it entirely closes the government as is contended that by petitioner and that it's needed for that rule to be invoked. That involves an exercise of discretion that cannot be compelled by mandamus. Rather, we're going to apply 8.406 to a particular set of facts is a discretionary judgment.
I question your reasoning, Mr. Paloon, because you're saying that before 8.406 applies, there must be a specific determination by the governor, in this case, that 8.406 applies, and therefore anyone who feels that they have entitlements under it must satisfy the conditions, as opposed to the conditions have been satisfied regardless of what the governor determines whether 8.406 applies or not. If Mr. Fisher makes the case that he has satisfied the conditions of the regulations, then the court could very well tell Mr. Ignacio that you need to comply with those regulations and not wait for a determination from the executive branch as to whether the section applies or not.
So I agree, generally speaking, that there's a means for reviewing this, but this is a procedural, the issue with mandamus relief is a matter of procedure, not a matter of closing somebody out of court. It's the availability of mandamus as the appropriate remedy. There is a remedy here to review the governor's decisions and the public health emergency rules as they apply to employees, and that is through the personnel administrative proceedings or potentially through a generalized civil action. I can't think of, there would be some other sovereign immunity issues there, but you would, mandamus is not the appropriate remedy. You have to have a clear and indisputable right to a very particular action by the government in order to do it. And the other thing too is we're dealing only with an administrative rule here, which hardly can create that obligation, a ministerial obligation on behalf of the government actor.
Let me follow up on this idea that you brought up, that there's an administrative proceeding or a regular civil action that would adequately redress the injury that Mr. Fisher's client is claiming here. My understanding of his argument as well in relying on subsection A is he's been deprived as an employee of his right to be on mandatory paid leave during the time that there's a disaster or a dangerous condition under subsection A. How is an administrative hearing or a regular civil litigation going to remedy that injury in a speedy manner? I mean, that his claim is under subsection A, I'm entitled to be on leave when a natural disaster or other emergency condition exists. And that exists, and therefore I have a right to be on leave. And you're suggesting that, and I don't think you cited any law that said that his request for paid leave during an emergency is one that can be addressed in a speedy and adequate manner.
So if it's really about compensation, which this really comes down to, it's a monetary claim that can be remedied through this. And so even if he's asking to be placed on paid
what if it's not money? He just doesn't want to expose himself. He wants to be on paid leave because of this unsafe working condition. And I don't want to go in.
But then if he's called back into work, even under his theory, if he's called back into work, there's an adequate legal remedy in the form of monetary relief that can make him whole after the fact for the work that he's performed. So he doesn't have a choice to say, I don't want to work. He can still be called in at the direction of his employer under his own theory. And then there is still an adequate legal remedy in the form of monetary compensation that can be awarded at a later time. He doesn't, it's not the employee's choice, rather to, even under petitioner's theory, whether to be placed on paid administrative leave or to continue working. That is the appointing authority's decision. And if there is a monetary remedy that can remedy that, and there is if he has to continue working, even under his theory, and they want double compensation. If that monetary relief is available under their theory, mandamus is not the appropriate remedy. But I also think that this comes into what really is one of the fundamental disagreements in this case, and that is the applicability of Rule 8.406 and how you actually interpret that rule. The petitioner, Topasna, makes a statement that the Superior Court did not even address Part A of Rule 8.406. And I think if you look at the decision and order of the Superior Court at page 7 from lines 8 through 19, you'll see that the Superior Court did address the issue of Part A and how it interacts with subsection C of that administrative rule. So it's not correct to say that they didn't address it. I really think that the issue is that Topasna disagrees with how the Superior Court addressed the legal question of how to interpret this statute. The statute, not the statute, this administrative rule. Let me be very clear about this. This is not a statute. This is an administrative rule. You have to read A, B, C, and D together. It's really a step A, step B, step C, step D. It's not an A or B or C or D. Because if you look under C, C starts with the word when, and it says when the governor declares. So this is conditioned upon something that has happened in B. And then B is conditioned upon the governor making an executive order for something that exists under A. So you go from A, that you have these things, to B, where the governors declare them, to C, when that happens, the appointing authority makes certain determinations. And certain determinations under C were not even met by the allegations in Topasna's complaint. The complaint alleges merely that portions of the government were closed to the public. It does not find that the government was closed, and additionally, other employees have to be put on excused leave. During the course of the public health emergency, employees may have been working from home, but they were all on regular work status. There's an executive order, that can be judicially noticed, pointing to that fact as well. And so when the governor declares these things, there are certain findings, and they just haven't met these findings in this particular case. And so that's even if we get into 8.406. But even if you find 8.406 facially meets that, you do have other issues to contend with in the fact that it's not, 8.406 is not something that's been legislatively approved. And so if we're setting rates of compensation in the government of Guam, and it's through a rule that hasn't been adopted by the legislature, we either have to defer to the statutes that set these things, or have to very narrowly construe what it is that we're actually paying out here. And really the natural disaster rule 8.406.
I understand your argument. The legislature has to pass a statute that allows for compensation as set out in the rule before the rule can be enacted, rather than the legislature authorizing the Department of Administration to enact personnel rules and regulations to administer the merit system. So there needs to be a specific statute that authorizes this before this rule can be validly enacted. Is that your argument?
Kind of, yes. The Organic Act gives two separate things. There's a merit system for protecting employees' employment. And then there's a provision that I cited to in my brief, that the legislature was responsible for setting the rates of pay for government employees, the rates of compensation. And so under that, the legislature either has to make some specific authorization related to pay, whether it's some sort of formula or some sort of specific rate of pay. What we have here in 8.406 is a rule that was promulgated solely by the executive branch and not even through the AAL at the time, because that was at a point in time when the Civil Service Commission was not subject to the administrative adjudication law. And so what we have is, I think there's an instance when you can delegate a formula by the legislature to the executive, but the executive can't make a rate of pay in the first instance. If we look at 8.406, though, it does have a couple of statutory counterparts, primarily one for compensation during a typhoon. And so if we're looking at 8.406, it's really meant for those type of natural disasters that last a relatively short or quantifiable period of time, and not an entitlement to double compensation over a protracted public health emergency related to a pandemic. Even when 8.406 and then the typhoon statute was being adopted, it's intended to really, place people on leave when there are, hazardous conditions that make it dangerous to go outside, and then typhoons usually pass within several days, and you may have cleanup and other things, but they are not protracted disasters to the tune of a year or more at this point. Most administrative leave given under those statutes is a short identifiable period of time related to a storm. And so we do have, for at least natural disasters, some statutory counterpart, but a public health emergency is not the same in kind.
So it's is it your thinking that this case poses is a good case for us to decide those issues in reference to the separation of powers, the non-delegation of authority on the part of the legislative branch to DOA in reference to compensation during a emergency condition other than natural disaster?
Specifically to 8.406, I do think that this could be an appropriate vehicle. I do think that there are a number of avenues to relief for the government here, including interpretation of 8.406.
Should we allow Mr. Fisher the opportunity to brief the issue, since it's only briefed one side?
He had that opportunity in his reply brief and merely claimed that the government waived that argument by not appealing it. We don't have to appeal a judgment we won. And so I raised the issue because we did raise it in the Superior Court. The Superior Court did not address it, but Mr. Fisher had the opportunity to address it in his reply brief and chose not to. But I also think that there is a way for this court to avoid the Organic Act issue by interpreting 8.406 in a way that resolves this case without having to appeal to the Organic Act's commitment of the issue to the legislature. Because if there is no claim, even under the face of 8.406, there is then no conflict at this time with the Organic Act, because we haven't implicated a compensation principle yet. And so, I really think that this goes to the last part of the brief, in which we go into deferring to the government's reasonable interpretation of the statute. The governor, the Department of Administration, and the Office of Attorney General at the earliest stages of the pandemic made really, when this issue was brought up, even through an opinion request from one of the legislators, made reasoned decisions related to the applicability of the rule in that under these particular circumstances. And the law is pretty clear that the agencies are entitled to, the government agencies and executive branch is entitled to deference in interpreting their own administrative rules. And it's certainly not an unreasonable one. So if the court ultimately concludes that petitioner has not met the requirements of 8.406, the issue of the legislative authorization could be avoided. And I think the canon of constitutional avoidance also dictates interpreting it in that manner. However, if the court does want to reach that, Mr. Fisher has had the opportunity to brief this particular issue and chose to forego it in his reply brief.
Is there any authority on this point that says only the legislature can set compensation directly, or that any attempt by the executive branch to set compensation would be inorganic? Is there any authority to that effect?
When it comes to duties and responsibilities and management of the executive branch, the closest counterpart would be the Guam Clearinghouse case. I did not cite that in my brief, but that's probably, probably one of the closest analogs at this time. I really think the better route in this case would be to interpret 8.406 in a way that avoids the Organic Act issue at this time. But at the same time, the Organic Act is pretty clear that the legislature sets the rates of pay. And that was an issue raised before the Superior Court.
But I don't think there's anything that says that that power is exclusive.
I don't know if that power, I don't know if that power is 100% exclusive, but in the sense that there is no statutory delegation either to any administrative agency related to rates of pay during a pandemic, only for the purposes of typhoons and other particular things like that. That's where the legislature can maybe delegate some of that to an executive agency, but there is no specific delegation that anyone can point to in this case to delegate that authority. But really, I think this gets into the problem of how you interpret 8.406, and whether even mandamus is an appropriate thing. If we're back to the mandamus issue, if we're getting into all of these questions of of how we pay people pay and other things like that are discretions of the legislature and executive, which are not something that can be committed through mandamus. And then 8.406, when read as a whole, shows that they haven't even, that Topasna, on behalf of his putative class, has not even alleged the necessary conditions to bring themselves within the purview of the text of 8.406. They have not alleged that any other employees were on excused leave, nor that the facility was closed. All they alleged is that it was closed to the public. Closed to the public is a very, very different term than closed. There are portions of the government that are always closed to the public. Closed is a very precise term that invokes things such as closures during typhoons and other things. Occasionally during typhoons, you do need police officers or other first responders out securing things or on the streets responding to situations. That's what the statute in 8.406 are actually intended to target, are those types of situations. What Topasna is making here is a relatively staggering claim that this rule also applies in a public health emergency over the course of an entire year, when that decision has been given careful consideration by the executive branch and found that 8.406 and the necessary conditions of it have not been met. So the government exercised its discretion in determining whether these conditions were met and whether to close the government or maintain it open under alternative arrangements. And that type of discretion is something that we commit to the executive branch. If you look at cases such as our and Kaiser and Securities Exchange, we give the executive discretion to do these things because they need to respond to emergencies sometimes in an uncertain territory. And we cannot predict through rules, regulations, or statutes every permutation of exigency that may occur. And so we commit those to the executive branch and our elected officials to make those particular decisions. And so the best route in this case would either to be find that mandamus is not the appropriate vehicle, or that as the Superior Court found, petitioner did not allege the necessary requirements even under the facial text of 8.406 to find that the rule even facially applies. And we can reserve for another day some of the other questions related to the Organic Act and other things. So for these reasons, the government asks that this court affirm the judgment of the Superior Court in denying mandamus, which is the inappropriate remedy in this case.
Thank you, Mr. Paldun. Mr. Fisher, you may complete your arguments. You might want to unmute yourself.
How about that?
I like saying that. Okay, go ahead.
You'd rather, I would think you'd prefer mute yourself. But anyway, thank you, Mr. Paldun. The proposition that the government can't appeal a judgment in its favor, I guess that overall it makes intuitive sense that that's true. But it seems like this decision is kind of rather a mixed bag for the government. We just heard about the inapplicability of mandamus in this issue, which they did not prevail on that issue, and they brought up the issue of the organicity or the constitutionality of setting compensations and so forth like that. They didn't like that aspect, so I don't know that a blanket inability to appeal by the government is necessarily true. I mean, there is such a vehicle as cross appeal. But anyway, nobody here is asking, for example, for Officer Topasna's rate of compensation to be changed from $15 an hour to $30 an hour. Nobody's quibbling over the amount of compensation. I just don't think this statute, this rule, can be read to be an affirmative stepping into the realm of setting compensation. I don't see that in this particular statute. Of course, you folks are the ones who are going to determine that. We also heard from the Attorney General about the purposes of this particular rule. I'm sure we haven't heard from them any authority for their proposition that this is a short-term remedy for transient or short-term problems. It simply doesn't say that in the rule. They're worried, I guess, about catastrophic financial consequences to the government of Guam. Maybe this particular scheme under 8.406 is not wise. Maybe it's not, but that's not for the court to determine. The court is to determine whether or not what the law is and then apply it in any number of different ways. Now, the AG also said, they were talking about the organicity of it. If the portion of this 8.406 is inorganic, because the court believes it does set compensation, and that brings us to an issue of overstepping, stepping out of their lane and getting into what the legislature should be handling. Does that mean that the entire statute would fail? Or are parts of, sorry, I keep saying statute, but I think the court knows I mean this rule. Does the entire rule fall, or are there portions of it that can be carved out and they survive? I think that probably the latter is probably the case, and I think that's in harmony with the way appellate courts usually approach constitutional issues. If they can save it, they'll try and save it. If they can't, they can't. That's the end of it. The other. We would ask the court to consider that if it's going to determine that it's inorganic, this compensation issue. They also said that the rule says talking about agencies closed, and I don't see in there any particular differentiation or dichotomy between closed and closed to the public. I don't see that, although the AGs have cited that. All that being said, I think the court understands that we feel, bottom line, we feel we were deprived of our rights to be heard on this particular section, 8.406A. And we're not asking the court to delve into the situation or to delve into an analysis if is mandamus correct here or is mandamus not correct here. You know, is this is the Civil Service Commission got out of their lane and are now impinging on the legislature's responsibility and right to set compensation? We're not asking for that. What we are asking for is that this court simply instruct the Superior Court, much like in that Nieves case. You know, we asked for something and we're asking the court to consider it, win, lose, or draw. But we feel like we are entitled to be heard on that issue, and we don't see that the Superior Court did it. And I mean, so we see this we don't see this at this point. We don't see this as nuanced as the AG does. We are just looking for an order from the court saying you guys need to consider that. And again, if we like the decision, we probably wouldn't appeal it, and the AGs would. Yes, ma'am.
Mr. Fisher, are you asking the court below to have just a review of the legal issue or also to hold evidentiary hearings?
Oh boy. I think it almost could be dealt with, I think, in like a summary judgment situation. Nobody, including the AG, is disputing the existence and the application of the executive orders. So this seems to me that a situation exists as a legal reality. There is an emergency, and because there's an emergency, certain things have to happen. I think the court could rely, they could take evidence in the form of declarations or witnesses, of course, but fundamentally they have to consider the issue. So I guess whatever satisfy the judge in the Superior Court would be what we were looking for, I think. All right, I guess I don't have anything more to add on that. Thank you very much. I appreciate you hearing this issue. By the way, I apologize for missing that hearing for whatever reason. It just was not on my schedule, and I do apologize. That was for the 1 month ago hearing. Thank you.
Yeah, and thank you for accommodating the request for the change from yesterday to today to both counsel as well.
Yes, sir.
Thank you, Mr. Fisher. Thank you, Mr. Pawloon. The court will take the matter under advisement, and this court stands adjourned.
Bye.